Good day, ladies and gentlemen, and welcome to the National Director Institute web conference series. At this time, all participants in a listen-only mode. Later, we will conduct a question-and-answer session, and instruction will follow at that time. If anyone should require assistance during the conference, please press star then 0 on your touch-tone telephone. As a reminder, this conference call is being recorded. I would now like to turn your conference over to your host, Ms. Jessie Allen. You may begin your conference.
Thank you, Operator. I'd like to welcome everyone to today's conference, which is the 7th session of our 2010-2011 National Directors Institute web conference series. Today's session is titled The Whistleblower Provisions of the Dodd-Frank Act. This is our 10th annual NDI, and as in years past, we are looking forward to sharing the insights and experiences on corporate governance issues that we think matter most to you. If you missed our prior 6 NDI webinars earlier this year, PowerPoint presentations and audio for those sessions are available on our dedicated NDI website, which is foley.com/NDI. And of course, we held our in-person 2011 NDI in Chicago on January 12th, for which program materials are posted to our NDI website as well. Our next in-person NDI will be held on November 17th, 2011 in Chicago, and details will follow soon, so please be on the lookout. We'd also like to take this time to thank all of our NDI co-sponsors, many of whom have been supportive to NDI for years. Aon Corporation, Deloitte & Touche, D.F. King, Eversheds, FD International, UBS, Vintage Filings, and in-kind sponsors Boardroom Bound, Corporate Secretary, and NASDAQ. Today, our very timely program, entitled Whistleblower Provisions of the Dodd-Frank Act, will be moderated by 4 of my partners here at Foley, each of whom has great experience in this area. Lisa Noller, a partner in Foley's Chicago office, is a member of the firm's Government Enforcement, Compliance, and White-Collar Defense, Business Litigation and Dispute Resolution, and Securities Enforcement and Litigation Practices. Paul Monsees, a partner in Foley's Washington, D.C. office, is a member of the firm's Labor, Employment, and Business Litigation and Dispute Resolution Practices, as well as the insurance industry team. Ken Weiner, a partner in Foley's Washington, D.C. office, is a member of the firm's Securities Enforcement and Litigation, Government Enforcement, Compliance, and White-Collar Defense, and Transactional and Securities Practices. And finally, Sandy Weiner, also a partner in Washington, D.C. office, is a member of the firm's Securities Litigation, Enforcement and Regulation, and Transactional and Securities Practices. Before beginning our discussion, just a few housekeeping items. Our conference today will last approximately 1 hour. During this time, you may submit questions via the Q&A tab, which is located on your menu bar at the top of your screen. You may also hold your questions for the live Q&A we expect to occur at the end of today's session. We will try to answer all of your questions during the program, but if we run out of time, we will follow up with you individually after the conference. We encourage you to maximize today's PowerPoint to full screen by hitting F5 on your keyboard or from the toolbar menu, selecting View and clicking Full Screen. If you would like to print or save a copy of today's PowerPoint presentation, you can do so by selecting the printer icon on the bottom right-hand corner of the screen. Foley will apply for CLE credit for you after the conference. If you did not already supply your CLE information when you registered, please email it to Elizabeth Harris at eharris, Harris, at Foley.com. Note that you must be logged on to both audio and video to obtain CLE credit. And now I have the pleasure of introducing Sandy Weiner to begin our discussion of the whistleblower provisions.
Thank you very much, Jesse, and welcome everybody. I wanted to speak today about the SEC and corporate response to a whistleblower complaint, and I'd like to move to the next slide, please. Ellie, if you could move to next, thanks. So typically how the scenario we often see, although the SEC gets leads from many other sources, when a whistleblower does approach the SEC staff quickly debriefs the whistleblower, often in person, usually through an interview as opposed to creating a transcript of testimony. At that very moment, the whistleblower is now sharing information that might be quite confidential at the company, but it's subject to the SEC routine uses of information, which entails sharing information with other government agencies, providing information, response to Freedom of Information Act requests, and the like. So that information is now probably not going to be maintained as confidential. The potential referrals can occur from the SEC to the Department of Justice or other federal and state law enforcement authorities. When the SEC decides to follow up on the information received from the whistleblower, they have to make a decision on whether or not they're going to defer their investigation while the company undertakes its own investigation. The SEC would reach out to the company, notify them of their interest in information, and the company has some decisions to make. First, and this is mandatory, the company ought to put a document hold with respect to documents that may be relevant to the focus of the SEC investigation. Secondly, management is going to want to notify their board of directors regarding the pendency of this SEC inquiry. And thirdly, the company needs to consider, depending on the nature of the information they receive from the SEC, of undertaking an internal investigation and whether or not it's appropriate at that time to provide disclosure to the marketplace regarding the focus of the SEC and what the company may want to do in response. Next slide, please. The internal investigation that the company may want to undertake is going to obviously be dependent on the scope and characteristics of the facts that have been received. The appointment of independent directors from the board of directors may be appropriate in certain circumstances to oversee the investigation. Given the skepticism that exists in the front office of the Enforcement Division of the SEC these days with regard to internal investigations, the integrity of those investigations and the ability of those investigations to ferret out information that is pertinent to the SEC concern, I think it's imperative that counsel and the company consider what can be done to demonstrate the reliability and credibility of any results of an internal investigation. Accordingly, having independent directors oversee the investigation may be one way to assist counsel in persuading the SEC staff of the reliability of the results of the investigation. In addition, the company may want to consider the retention of independent counsel not typically engaged to perform work for the company. At this time, the company again needs to consider what disclosure, if any, it may want to make with regard to the pendency of an internal investigation. Periodic consultation between counsel to the company and the SEC staff regarding progress on the investigation is a way to acquire some additional credibility with the SEC staff and offers the company an opportunity to tailor-make its investigation in a way that reduces the chances that the SEC will cover the same ground all over again. So staying in close touch with the SEC staff can save money down the road. The company will have to make a decision between alacrity and comprehensiveness and try to find that proper balance in terms of completing the investigation. The SEC is not going to sit back indefinitely waiting for the company to complete its investigation, and indeed may not sit back at all. But with some, with some demonstration of the effectiveness of the investigation, you may be successful in persuading the staff to wait. But they won't wait forever, and so you have to decide where to cut off the investigation, and that's really one of the hardest decisions any investigator makes. The company would be well advised to consider prompt remediation of any problems they encounter as a result of the investigation, since that prompt remediation can go a long ways toward establishing the company's credibility with the enforcement staff and may be part of the presentation the company wants to make to persuade the staff to forego bringing enforcement proceedings at the end of this, or at the very least minimizing or eliminating a potential penalty. The company is going to want to consider how to report the results of its investigation, whether it's in writing or not, and to whom the report should be made, whether it's certainly a report will be made to the full board. The staff will have to decide how they want to report their the results of the investigation to the SEC staff, and whether or not reporting to the markets is appropriate. Next slide, please. The SEC investigation that would ensue, assuming they waited until they received the results of the company's investigation, would nevertheless not be, would be some effort to kick the tires to evaluate the quality of the company's investigation. You could expect document requests or subpoenas for documents to be issued to gather information, as well as the SEC staff deciding they want to take investigative testimony of the key recipient witnesses. company's counsel, and it may be counsel different from the one who conducted the investigation, quite possibly, although not necessarily. The counsel is going to have to make some decisions as to whom the counsel is going to be able to represent. There's a strong sentiment at the Enforcement Division it's not appropriate for company counsel to represent every witness that visits with the SEC and provides testimony. At the end of the document production and testimony, the staff sits down and tries to determine whether or not they believe a violation of securities laws warranting enforcement action has occurred. At this stage, it's very important for company counsel to consider engaging the staff in a dialogue and trying to see if the concerns of the staff can't be allayed in orally or in writing at this stage prior to the commencement of what is referred to as the Wells process, which is a process that's triggered by the SEC staff reaching a preliminary conclusion that a violation of the law has occurred and that enforcement proceeding is appropriate. If the submissions of the Wells process are not successful in persuading the staff to close their investigation without action, then we often find ourselves considering whether or not the company is interested in trying to seek a settlement of any potential SEC claim in advance of the filing of any enforcement proceeding. Next slide, please. The enforcement proceeding can be in a federal court or it can be before an administrative law judge. It's in the discretion of the SEC as to which direction they go. Typically, the SEC would not feel itself limited to proceed solely against the company, but would believe individuals ought to be considered as defendants as well, in light of the fact that in the SEC view, if there's a violation of law, it didn't occur because of the corporation so much as occurred because of the conduct of certain individuals. The SEC at this time may, if it hasn't done so already, consider referring the facts that they've uncovered and consider cooperating with other law enforcement authorities. In connection with the enforcement action, the SEC is going to be considering what sort of sanctions and relief it ought to obtain, including penalties, disgorgement of monies that were arrived at as a result of misconduct, and may even consider the appointment of an independent consultant to ensure that the company's procedures and controls provide greater assurance of no future misconduct. Another reason why prompt remediation before this stage of the investigation and enforcement actions is undertaken, because the independent consultant can be costly and can result in the determination that the company needs to adopt procedures that aren't really well tailored to the needs of the company. Next slide, please. Typically, SEC enforcement proceedings often are followed by or run parallel with securities class actions under Rule 10b-5, shareholder derivative actions, and ERISA actions. And certainly we have seen instances of disgruntled employees, not only the whistleblower himself or herself, but also employees similarly situated wanting to bring actions for retaliation or the receipt of some sort of demotion or other kind of adverse action perceived to be a result of the company not following up on their criticisms. Next slide, please. Next slide, please. Accordingly, we think that a pre-existing robust securities compliance program at the company, along with a cooperative and meaningful corporate response, which may include internal investigation and dialogue with the SEC, will often significantly mitigate the fallout from whistleblower action. And I think we ought to pick up here with Ken Weiner, who's going to speak to you about the overview of the whole set of bounty provisions within the Dodd-Frank legislation and the SEC rules. Ken?
Thank you. Okay. In July of 2010, Congress passed the Dodd-Frank Act. And the Dodd-Frank Act amended the Exchange Act to add Section 21F, which established an SEC whistleblower program and required the SEC to adopt rules implementing the program. Dodd-Frank provided in part that the SEC must pay an award or awards to whistleblowers who voluntarily provide original information that leads to successful SEC actions, resulting in collections of at least $1 million, and that this bounty award must be between 10 and 30% of the sanctions collected. I'm going to provide some highlights of the bounty rules that were recently adopted by the SEC. When the SEC proposed these rules back in November of 2010, probably the most controversial aspect of the proposed rules related to the tension between the bounty program and the maintenance of effective compliance programs. When the SEC adopted Rule 21F on May 25th of this year, the rule that implemented the SEC's Dodd-Frank program, it tried to at least partially address those concerns. In today's program, I would discuss some highlights of the rule, including some of the respects in which the SEC attempted to address the tension between the bounty program and the maintenance of effective systems of corporate compliance. Primarily, I will address three aspects of the rules governing the whistleblower bounty programs. I will address the requirement that the submission of information to be voluntary, that the information submitted be original, and I will discuss some of the exclusions to the definition of original information. These exclusions were designed to help prevent or at least mitigate some of the unintended consequences that might otherwise result from the whistleblower program. Okay, so let's first talk about the concept that to be awarded a bounty, a whistleblower submission must be voluntary. The primary issue that the Commission struggled with respect to this aspect of the rules was whether a submission by an individual should be considered voluntary if, for example, the SEC or another government agency has already contacted the individual's employer with respect to the subject matter of the submission, or the employer has already contacted the employee requesting information related to the subject matter of the submission. As adopted by the Commission, Rule 21F takes a fairly broad view of when a submission will be considered voluntary. Under Rule 21F, the submission of information is not voluntary only if the request specified by Rule 21F was directed to the whistleblower or to the whistleblower's representative. A request is covered by Rule 21F only if the request relates to the subject matter of the whistleblower submission and was issued by the Commission, by the PCAOB in connection with an investigation, inspection, or examination, or by Congress, any other authority of the federal government, or a state attorney general or regulatory authority in connection with an investigation. The next aspect of the rule that I want to discuss is the requirement that the information submitted be original. As set forth in the statute and in the regs, for information to be considered original, it must be derived from independent knowledge or independent analysis, not already be known to the SEC, and not be derived exclusively from public sources. Now, in defining original information, the SEC carved out a number of exclusions, as I mentioned before, that are largely intended to avoid or mitigate some of the unintended adverse consequences that might otherwise result. It carved out exclusions for attorneys, and I'll discuss those in more detail in a moment, as well as for compliance individuals. It also has an exclusion for individuals associated with public accounting firms who learn the information in connection with an audit or review that's required by the federal securities laws. It has an exclusion for violators of criminal law. Now, this was an issue of some debate. There was a concern that it might appear improper for someone to commit a tort or a crime in order to obtain information to provide to the SEC, and for the SEC to reward that tortfeasor or criminal by giving that person potentially millions of dollars of a bounty award. And the SEC took a fairly narrow view of how to deal with that concern. Basically, it did what the statute required, which was to say, okay, if someone has been convicted of violating criminal law in connection with obtaining the information, and then that individual is not eligible for an award. And then there are a number of other exclusions as well. The first of the exclusions that I want to spend some time discussing relate to attorneys. In general, Rule 21F excludes from the definition of original information that an individual obtains through either a communication protected by the attorney-client privilege or otherwise obtained in connection with the legal representation of a client. Now, there are exceptions to this exclusion. That is, there are times when an attorney can be eligible for a whistleblower award. And the primary exceptions are instances when disclosure is permitted by the SEC standards of professional conduct, by applicable attorney conduct rules, or otherwise. Interestingly, while the SEC is somewhat deferential here to attorney-client relationships, it will pay bounties to whistleblowers who act in violation of other relationships that are typically respected by state and federal law, such as the husband-wife relationship, the priest-penitent relationship, and the doctor-patient relationship. The other exclusion that I want to spend some time here discussing relates to individuals who are involved in compliance. In general, Rule 21F excludes from the definition of original information that an individual obtained as a result of being an officer, director, partner, or trustee of an entity, if that individual was informed of the alleged misconduct by another person. It also excludes original information that an individual learned in connection with the entity's processes for identifying, reporting, and addressing possible violations of the law. It also excludes information that an individual obtained as a result of being an employee whose principal duties involve compliance or internal audit responsibilities. The somewhat narrow scope of this exclusion is important. In the adopting release, the SEC indicated that this exclusion does not include every supervisor involved in control functions or in processes related to CEO and CFO certifications. To qualify for this exclusion, it must be one of the principal duties of that employee to be involved in compliance and internal audit responsibilities. Similarly, the SEC excluded from the definition of original information that an individual obtained as a result of being employed or otherwise associated with a firm retained to perform compliance or internal audit functions for an entity, or to conduct an inquiry or investigation into possible violations of law. So the exclusion applies equally whether your internal audit and compliance function is performed by employees or is outsourced to a vendor. Now, there are exceptions to these exclusions as well, and they appear to be broader than the exclusions for attorneys. I have them set forth in this slide. So a compliance person is eligible for an award if that individual has a reasonable basis to believe that disclosure of information is necessary to prevent an entity from engaging in conduct likely to cause substantial injury to a financial interest or property of the entity, or is necessary to prevent an entity from impeding an investigation of misconduct. In addition, there's a time period exception. So a compliance official, after 120 days have elapsed since his supervisors or the chief compliance officer or the chief legal officer or the audit committee has received information, is then free to contact the SEC and be eligible for a bounty award if the provision of that information triggers the commencement of an SEC investigation that results in a successful enforcement action that otherwise qualifies or significantly assists in an investigation that has already begun. So that's very important, that there's this 120-day period after which compliance people are free to contact the SEC. Another source of time pressure comes from a provision that if an individual reported original information through an entity's internal procedures and the entity later provides to the SEC either that information or the results of an audit or investigation initiated in response to that information, the SEC will consider the individual to have provided original information that led to the successful enforcement action if the individual submitted the information to the SEC and within 120 days of providing the information to the entity contacts the SEC. And the information provided to the SEC either causes the SEC to commence an examination or investigation that results in a successful action that results in the collection of $1 million or more or significantly contributes to the success of such an action. So that, to the extent that an employee is motivated by the prospect of collecting a bounty, puts pressure on that employee, even in the unlikely event that employee initially goes through the company's internal reporting process, to then go to the SEC within 120 days. Now, one concern that came up in the context of the proposed rule was, did the rules or proposed rules create a disincentive to companies to conduct internal investigations or internal audit procedures to assess whether there were violations or possible violations of the federal securities laws? There was a concern that individuals who learned of potential violations through interviews or document collections conducted in connection with internal investigations might then use that information to make a submission to the SEC that might make the individual eligible for a bounty and would result in a premature and perhaps misleading report to the SEC. To some extent, the SEC did address that concern in Rule 121F. Under the rules as adopted, if an employee learns about a possible violation as a result of the internal investigation, then the employee will not be eligible for a bounty unless certain exceptions apply. So there is some limited comfort in that respect. So one of the questions that people are asking is, so isn't a whistleblower likely to report a concern internally before reporting the concern to the SEC? And obviously, to some extent, that answer to that turns on the corporate culture and the seriousness of the violation. But most of the attorneys I talk to who represent whistleblowers tell me that if they think it's a substantial issue that might trigger the concerns of the SEC and result in the SEC commencing an investigation, it's unlikely that they would advise a client to report the information to the company before going to the SEC. They might, however, advise a potential whistleblower to report simultaneously internally within a company and to the SEC. Okay, now we're going to cover meeting with the government, and this will be covered by my partner, Lisa Noller. Lisa?
Thank you, Ken. What I'd like to cover here is something that I learned in working for the government. Prior to coming to Foley, I was an assistant U.S. attorney for 10 years in the civil and criminal divisions, and also worked with the SEC on a number of parallel investigations. And one thing that I would like to emphasize is that just because there's a whistleblower claim, it does not mean that the SEC or DOJ is going to file a lawsuit or charge the company. You often have an opportunity to go in for a meeting with the government and spin the case in light of what you've determined through your own internal investigation. If you decide that you are going to meet with the government, either because you've been invited or because you believe that you want to proactively approach them, the first thing to determine is who you want to meet with. Obviously the SEC, and secondly, the question is really whether DOJ is involved or not. If through your own internal investigation you believe that criminal conduct has occurred, there's nothing wrong with asking the SEC if they've made a referral to DOJ. They don't have to tell you. Sometimes they do. You also should let the SEC determine who they're going to invite. Don't invite DOJ to the table, in other words, on your own. But when you're going to be meeting with the government, basically you can choose your own approach, which is whether you're going to be reporting and responding to a whistleblower or accepting an invitation. In either event, there are two things that I would encourage all people meeting with the government to keep in mind. First is to document all efforts that you've made to that point to comply with a reasonable response, which will show the government that you've taken the allegations or the suspected allegations seriously. But the other thing I'm going to focus most of my presentation on today is that the most practical and relevant presentation you can make is one that is tailored to what the government people that you are talking to need to answer internally. Every single person is going to be asked questions by their superiors before they determine whether or not to file a lawsuit or bring charges. And I'm going to give you a roadmap for maybe making a presentation that is more tailored to what they need to know. It's based on the principles of federal prosecutions of business organizations. This is colloquially called the Phillip Memo, which is after a Deputy Attorney General who was the last person to revise this document. It's in the U.S. Attorney's Manual. All criminal AUSAs are required to do an analysis of these 8 factors before they can recommend charges. Civil AUSAs are recommended to follow this, but in any event, it's a good roadmap because it provides the government the information that it needs to know. The first factor is the nature and seriousness of the offense. And these are all things that you can determine through the course of an internal investigation. Basically, who was harmed here? Has the company lost shareholder value because of the actions of a rogue employee or by the company? Has the marketplace been altered? You need to be prepared to present data because you need to assume that the SEC has the same data available to it. So basically, market trends, industry analyst reports, that sort of thing. You also should be prepared to discuss with the government what the amount of loss is and to whom any money is owed. If there is in any way, shape, or form a loss to a federal program, the likelihood that DOJ will be involved or there was a referral to DOJ is much greater. You also need to be able to respond to a question about how to apportion responsibility where it's appropriate. The second factor that DOJ considers is the pervasiveness of the wrongdoing, and it's actually a very simple calculation. Where there are many violators or where the offense was condoned by corporate management, in most instances, DOJ's direction is going to be to charge or sue the corporation to get a remedy. In instances, however, where there's a single act by a rogue employee, the response will be to charge or sue individuals who are responsible for that wrongdoing. But in either case, the question is, what did management know, what did management condone, and what did management do? To Sandy's initial point, that's a really good reason to have an independent person overseeing any sort of internal investigation to determine whether or not management is responsible for any of the alleged offense. The third factor is past history. And it's very easy when you're conducting an internal investigation in response to a whistleblower complaint to say, okay, we believe the whistleblower has identified issue X. But really what the government is going to be asking when you're sitting across the table from them is, did you look at expanding issue X to determine whether there was a more pervasive problem in your entity? And so past history sort of gets to that, which is, did you have any warning signs leading up to the whistleblower's allegation that you should have taken heed of? The U.S. Attorney's offices, in connection with this factor, must consider non-criminal guidance, which includes advisory notes to regulations, reported decisions, and industry publications, and any warnings, sanctions, or previous charges to this entity. They also may consider things like corporate structure. So, for example, is the wrongdoing alleged to have happened at a European subsidiary or a privately held company that used to be acquired or used to be held by the publicly held company? The fourth factor is a timely voluntary disclosure and cooperation. And basically the question here is, as an entity, are you willing to provide full and truthful information? And that doesn't mean sending your attorney to meet with the government. It means, is there somebody in management that the government can talk to find out exactly what happened here and what went wrong, if there was anything that went wrong. This also means that the corporation needs to take responsibility if, in the course of an internal investigation, it also finds that there was wrongdoing. So did they take action to promote, fire, transfer people, and why did they do that? It's uncomfortable to terminate or discipline bad actors, but it shows that the company is taking allegations seriously. The fifth factor to address in any meeting with the government is the existence and effectiveness of a pre-existing compliance program. And ever since Sarbanes-Oxley, most entities, and in fact all publicly held entities, must have this. In the course of your investigation, this again seems pretty simple, which is find anything, any evidence that can be considered part of training, compliance, or remediation. But more importantly is this third bullet point. Does management know and understand the internal compliance programs and the remediation that's been done in the face of a whistleblower allegation? I cannot tell you how many times I sat across the table from attorneys who would tell me that their management, the management of the company knew and understood the compliance program, and they really could, conduct themselves with the utmost integrity. And then you talk to that manager and ask them for details about the compliance program. And I'm not talking about nitpicky things, but basically, what sort of training do you provide to your employees? And the manager just stares at you. And so really the question here is, does the compliance program have teeth? And one thing that I'm including in the slides, but I'm not going to go over, is this slide, which is what the U.S. sentencing guidelines say are 7 components of an effective program. And basically what it boils down to is not just that you have something on paper, but are you conducting any sort of an internal review and communicating the policy to every single person from the top down? You want to be able to tell the government that you have the mechanism in place to be able to remediate and address any whistleblower concerns. The 6th Philip factor is remedial actions. Basically, in the wake of an internal complaint or even an external reporting to the SEC, once you found out about it, did you take any remedial action? Did you discipline or terminate people? Did you replace responsible management? Are you prepared to pay restitution? Are you prepared to bring people in who can answer the government's questions? The 7th issue that the government looks at is whether there are collateral consequences to a lawsuit or an indictment. And this is something that as an entity you can really spin in your favor, which is to present to the government the harm to shareholders, pension holders, employees, or the public generally that would result from a publicly filed lawsuit or an indictment either of the corporation or of responsible decision makers. With respect to debarment, any effect that any sort of government action would have on government contracts is something that the government takes very seriously. If you believe that you've got a lot of arrows in your quiver, it's really a good idea to pitch a non-prosecution agreement or a deferred prosecution agreement. I think it gives you a lot of credibility to be able to say, look, somebody reported this internally. We understand that they've gone to the SEC, and we too believe that there may be an issue here. But rather than sue or indict, we'd like to be in a position where we can help our own entity restore its integrity and preserve our own financial viability, and you can do that through a deferred prosecution agreement. The 8th factor is the adequacy of alternative remedies. Particularly on the criminal side, the goals of a criminal prosecution are supposed to be deterrence, punishment, or rehabilitation. So gather facts to pitch a satisfaction or one or more of these goals. The last thing that I would encourage you to present to the government affirmatively is the whistleblower's role in recovery. Basically, the whistleblower is going to be the government's primary witness, and in the course of your own internal investigation, it's useful to investigate facts that would inform the whistleblower's characteristics or credibility and present those to the government. In Dodd-Frank, they've got a list of issues that the SEC is directed to take into consideration determining the amount of recovery that a whistleblower is entitled to. These are the same factors that you should be looking at in determining whether or not the whistleblower is going to be credible. And if you can look at the government and say, you really don't want to put this guy on the stand because he's going to get killed on cross-examination, that's a very useful factor for the government to consider. So in the end, if you decide that you need to meet with the government either because you've been invited or because you want to get in front of a whistleblower complaint, I'm hoping that you'll take these 8 factors into consideration and basically tell the government what it needs to know so that when that person is presenting to his superiors whether to charge or not charge, he can basically have your information in the back of his head. Now I'm going to turn it over to Paul Monsees to talk about whistleblower retaliation protection.
Thanks, Lisa, and good afternoon, everybody. This is Paul Monsees in the Washington office. Wanted to switch gears a little bit to talk about the anti-retaliation protections in Dodd-Frank. While you were focusing on the government, either the SEC, or the Department of Justice, preparing your pitch to the government, as Lisa was just discussing, you also have the issue of the employee, most likely a whistleblower is an employee, is still at the workplace. They have brought forward some information, and this statute specifically provides that they are protected from retaliation. So we're going to go through some of the factors that address how you determine who is protected from retaliation, what retaliation is, and some other factors. And we'll do that because the statute does not say much about this topic. Unlike Ken's presentation, where there are many rules and specific provisions about what is voluntary submission and what is original information, the statute says just this about no retaliation. No one may discharge, demote, suspend, etc. A whistleblower in the terms and conditions of employment because of a lawful act they have done in providing information to the Commission, participating in an investigation, or reporting under SOX or some other provisions, and that's all it says. What the advisory notes with the final rules referred to was that there is employment law that's been fully developed that can address how to determine if some act which is deemed retaliatory is because of protected activity. So we'll discuss some of that. In this slide 37, we have what is briefly set forth in Dodd-Frank about who a whistleblower is. So it's an individual who provides, or two or more individuals acting jointly who provide information to the Commission. The standards to be eligible for the bounty, as Ken discussed, as I mentioned a moment ago, can be detailed, and there will be some scrutiny of a number of very specific points to determine if someone is eligible for a bounty. On the contrary, to determine if someone's protected from retaliation, the standard is different. You don't need to be eligible for a bounty to be protected from retaliation. The standard is, does the person who's reporting the information have a reasonable belief that they are providing information about a possible securities violation? The reasonable belief standard was incorporated into the final rules 2 weeks ago. As this slide points out, the statute says reporting about a violation. The proposed rule last November talked about information about a potential violation. So this was a compromise suggesting that what is being reported about basically has to be an imminent violation of securities law if it hasn't already occurred. But the key takeaway on this is that the determination whether somebody is a whistleblower for purposes of being protected from retaliation is made when the information is submitted. Did they have a reasonable belief when they submitted the information? So it will not depend on all of the detailed issues about original information and so forth. The other point about the reasonable belief issue is the person can be wrong. You can ultimately be found not to have committed a securities violation, but that person is still protected from retaliation. And the retaliation point from this statute is important because we know from employment law principles, and if we look at EEOC statistics, for example, in the last fiscal year 2010, the most common charge out of 100,000 EEOC charges made that year was retaliation. So more than race, more than age, more than gender. So it is the most prevalent claim. It obviously can be joined with those other claims. But retaliation in the employment context is now the most often cited claim in EEOC statistics. And one would expect, given that Dodd-Frank is trying to encourage people to come forward with information, that the protections against retaliation will take a very high profile. So you have the persons who are protected are the person who brings the information forward, also people who participate in an SEC investigation, for example, but you can also have other people who could be eligible for protection, and this is a concept borrowed from the employment law context in this Thompson case, which was issued by the Supreme Court earlier this year, where they embraced something called associational retaliation. And what that meant in that case is that an employee filed a discrimination complaint with the employer, and the employee's fiance worked for the same company, and the fiance was fired. The fiance filed a retaliation claim, and the objection was, well, the fiance didn't engage in the protected activity because it was his fiance who filed the complaint, but he did not do anything. And the Supreme Court, based on what it called the zone of interest test, said, as I quote, it's obvious that a reasonable worker would be dissuaded from engaging in protected activity if she thought her fiance would be fired. So the zone of interest discussed by the Supreme Court in that case about Title VII was you want to make sure that an employer doesn't take action that will interfere with someone exercising their rights under Title VII. And one can certainly see that the zone of interest under Dodd-Frank would be similarly broad if the SEC is trying to encourage people to come forward. So in that case, the question is, well, what other interests might be protected by this associational retaliation concept? There we had the fiance, and the fiance worked for the same company. Justice Scalia in that case in dicta, because these were not the facts, basically said if you fire a family member of someone who files a discrimination claim, you will violate Title VII, and that will be retaliation. And then he said to take the other end of the extreme, to say if you take a lesser action against a, quote, mere acquaintance, unquote, he said that would almost never violate the standard. So then the question is, what is in between? And how will that be interpreted in the face of other facts? The next bullet, just quickly about this, Florida federal court found where there was a vendor at a healthcare facility had an outsourced vendor that provided a bunch of the services. An employee for the healthcare facility filed a disability claim. Her spouse worked for the vendor, so her spouse had a different employer. The spouse was fired by the vendor, and the claim by the spouse who was fired was, well, I'm being punished because my wife, who works for the healthcare facility, filed a discrimination claim. So it was not the same employer, and in response to a motion to dismiss, it's early in the case, the motion to dismiss by the company was denied. So the court said that fired employee of the vendor stated a claim for this associational retaliation. So it could be quite broad. An interesting point will be this concept was expressly included in a different provision of Dodd-Frank, which amended the False Claims Act, and it was not expressly referred to in Section 922. So there could be an argument that this concept should not apply to Dodd-Frank retaliation claims, but we'll have to see how that works out. Let's look at some other employment law concepts. As I mentioned, the release on May 25th with the final rules referred specifically to the fact that there is a, quote, well-established legal framework in employment law relating to determining whether an adverse action was because of protected activity. That typical employment law framework is employee shows they engaged in protected activity, suffered some adverse employment action, and as we'll see, what that is can be subject to dispute. And they also need to show that there was a causal connection. The way that's often shown is simply by saying, I engaged in protected activity in May, and the adverse action was in June. So the fact that it was close in time usually satisfies that part of the test. Then the burden shifts to the employer to basically say there was a non-retaliatory reason for the action we took. It was based on a performance review. There was some unethical behavior that was engaged in by the employee, et cetera. And then the employee has the final burden to show that the offered reason by the employer was a pretext. And what is most often done to try to show pretext is to look at other similarly situated employees and basically to try to show that for similar conduct, other employees did not suffer the same adverse employment action. They got a warning instead of being fired, or nothing happened to them instead of being suspended. So they try to show that what the employer gave as the reason must not be the reason because they were not consistent in applying that standard to other people. Another concept from the Supreme Court in this 2006 case is what is the standard that a court will look to determine if someone is being retaliated against. And in this Burlington Northern case, which was in a Title VII case where the employee had a change in their assignment. So they were reassigned to another position. They were also suspended without pay for a period of time. And interestingly, they were reinstated after the company investigated and determined that there was no real good basis for the suspension. So the Supreme Court looks at whether or not that was retaliation, and the standard announced was, would whatever the employer did dissuade a reasonable worker from making or supporting a charge of discrimination? Pretty broad standard and seemingly easy to establish. Anything that might dissuade someone from coming forward, keeping in mind that what in the employment context, the person wants to keep their job and their salary and their benefits. The next bullet by Justice Breyer about this Burlington Northern case was dicta because these were not the facts in the case. But he suggested, a schedule change could, in certain circumstances, be retaliatory. Excluding somebody from something that was for professional advancement could be retaliatory. We have the other bullets refer to some other cases where courts have held that basically disabling someone's security access to the building or their access to voicemail and email could be deemed retaliatory. The Wisconsin case, the Chrysler case, is one where the supervisor threatened termination but ultimately did not terminate. And the court in that case held that that could be an adverse action sufficient to support a claim for retaliation. So my question, the last point on this slide is, if the Burlington Northern standard really will apply similarly to a Dodd-Frank retaliation claim, because if the test about someone whose employment is at stake is, are they going to complain if they fear some impact on their job, that can be a standard that might be easy to meet. If you're looking at Dodd-Frank and what the employee is doing is reporting something to the SEC, presumably motivated at least in part by possibly receiving up to 30% of a large enforcement action sanction, so they might get a bounty of, let's say, $5 million. My view would be that you need more tangible employer action, more adverse action than disabling someone's voicemail in that circumstances to satisfy the standard as to whether or not that's retaliatory. But that's where the courts will hash that out. The next slide I just put in quickly because there was a recent case reviewing the anti-retaliation provisions of Dodd-Frank, and there are a number of points in that case, but the one thing I wanted to highlight was we looked earlier at the definition of what a whistleblower is, and it was an individual who provides or two or more people who jointly provide information to the SEC. This case considered a person who reported internally about misconduct and diverting company assets, reported it to the president. President informed the independent directors. They hired outside counsel. Outside counsel interviewed the whistleblower, got more information, and at least according to the complaint, outside counsel confirmed the allegations that the whistleblower made, and then the CEO fired the plaintiff. One of the issues in the case was the employer said there's no basis for the retaliation claim under Dodd-Frank because they didn't complain to the SEC. Long story short, the court said, well, you went to outside counsel and you talked to outside counsel and you expected outside counsel to bring that information to the SEC's attention. Therefore, you could be deemed to be acting jointly with outside counsel in reporting to the SEC. Very interesting. We'll see where that goes. Quick things just on the statute, which it does provide that there's an immediate right of action in federal court. Unlike Sarbanes-Oxley exhaustion requirement, there's a 6-year statute of limitations, and the significant remedy is the double back pay, which is not something in Sarbanes-Oxley. And then just the last slide on some takeaways about what to do with these types of claims. As others have said today, the first couple of points are what can you do in advance, have a strong policy. Did you demonstrate compliance with it, meaning do you enforce it, do you investigate when you receive complaints, and training about what retaliation is. Factors to consider when you're considering adverse employment action include what is the conduct that you're trying to punish. Is it objective, meaning someone missed a deadline, violated a rule, or is it, gee, the person's not a team player type of thing? And then I mentioned there, as we said before, how did you treat other people who engaged in the same conduct? And then the last bullet, upon receiving a written complaint, what do? Obtain a statement of what the conduct is, so you know exactly what it is you need to investigate and what they're not complaining about. One point about, given the Evans case we mentioned, make clear to the whistleblower you're not acting jointly with them to investigate this complaint. And then the last 2 points arise out of the cases we looked at. Does the decision maker know that the whistleblower is a whistleblower? They might not know, and therefore the whistleblower could not say action is taken because of their protected activity. And the last point refers to the Thompson case. If you're considering adverse action, does that person have a relationship with someone who's a whistleblower? So those are some points and some takeaways on the retaliation points, and we'll turn it back over for, I believe, some final thoughts and any questions that any of you have.
Ladies and gentlemen, if you have a question at this time, please press the star and the 1 key on your touch-tone telephone. If your question has been answered or you wish to remove yourself from the queue, please press the pound key. Once again, if you have a question at this time, please press the star and the 1 key on your touch-tone telephone. I'm not showing any question at this time, sir.
Yeah, we do have 2 very good questions. This is Sandy Weiner that I'd like to quickly answer and then wrap up the call. First question was, what are some procedures or programs that companies are putting into place to reward employees for informing them of wrongdoing first versus reporting directly to the SEC? And, these rules are so new, I'm not sure how many companies have modified their normal hotlines and whistleblower procedures to address the SEC-specific rules, but I would ask Ken or Lisa if you've seen companies' modifications to their normal whistleblower procedures to try to motivate or reward employees for informing the company of the wrongdoing first.
So this is Ken. Let me go first. What I've seen is a lot of discussion of how to establish mostly a tone that encourages companies to report information internally rather than going immediately to the SEC. There seems to be a consensus, at least among many of the attorneys I've talked to, that it is appropriate for companies to urge employees to report information internally. There's more concern about whether it's appropriate to urge employees to report internally before reporting to the SEC, because to some extent that's discouraging employees from reporting to the SEC. So a lot of what's involved is establishing credibility with employees that a company has an effective system of compliance. Because to some extent, a lot of what employees see are not going to result in multi-million-dollar sanctions, and the bounties therefore are less important. And so what's important with respect to those sorts of issues is to encourage employees that if they have a concern, the company is in fact receptive to hearing those concerns and will respond appropriately to those concerns.
The only thing I would add to that is basically a point that maybe Paul can comment on, which is that reaffirming to company employees that they will not be retaliated against for reporting wrongdoing may be another way to incentivize people to come forward internally rather than externally.
Yeah, I agree. You certainly want to have, as I said in the slide, an anti-retaliation provision in your policies, and that you promote that and educate everyone about that, because it applies equally to employment discrimination and harassment and non-Dodd-Frank concerns as well. So you want to have that policy anyway.
A couple of other questions. One was, do you recommend that companies educate their employees about the Dodd-Frank provisions with respect to whistleblowers? And I would say absolutely with respect to senior and mid-level management. In order to achieve compliance with all of these requirements, you're going to need supervisors who are knowledgeable about them, and frankly, you're going to lose points on your compliance program in any dealings with the SEC or DOJ if you haven't developed some protocols to deal with that. And finally, the question, are you aware of companies considering using corporate ombudsmen to a greater extent differently to encourage ways to resolve issues without going to the SEC? And I think that yes, I think we're seeing just in terms of people trying to develop procedures under the hotline procedures under Sarbanes-Oxley, we've seen more use of corporate ombudsmen, or indeed hiring outside consultants to assist in that effort. I would expect we'll see perhaps more of that. I think it's a little too early to tell what companies are actually going to do in response to these new rules, but if the past is prologue, I think we may see either corporate ombudsman, sometimes you see the chair of the audit committee, or other people to, as Ken says, have that person appointed in a more formal role so that the tone within the company is influenced by actual concrete conduct by the organization to show they're taking this very seriously. I think that may conclude the questions, and I want to know whether or not there are any other questions before we sign off.
We have one question.
Okay.
From Kitty Wilson. You may proceed. KP, if your phone is on mute, can you please unmute your line? I'm not showing any further questions, sir.
Okay, well, I want to thank everybody for their time and attention. I think we're just going to have Representative Foley and Lardner sign off for us, and I thank you all and wish you a good afternoon.
Thank you, Sandy, Ken, Lisa, and Paul. We hope everyone enjoyed today's presentation. We also ask that you take 30 seconds to participate in our brief online survey at the conclusion of this call. That survey is very helpful to us in ensuring that our NDI programs are providing you with the practical advice and recommendations that you are looking for, and for also developing ideas for future NDI topics. So thank you again for attending, and we'll talk to you next on July 20th, 2011, as we address Director and Corporate Secretary duties in foreign countries. Thank you.
Ladies and gentlemen, thank you for participating in today's conference. This concludes the program. You may now disconnect, and everyone have a wonderful day.